We now turn to the third case on this morning's docket. It is case number 108648 in the matter of Mark Allen Galloway.
May it please the Court, Kate Baird appears on behalf of the Disciplinary Administrator's Office. I would request that 3 minutes be reserved for rebuttal should it be necessary.
3 minutes is granted.
Thank you. The matter before the Court, the matter of Mark Galloway, was presented to a panel on May 2nd of this year. Just prior to the hearing, the respondent stipulated to relevant facts and rules violations, including violations of 1.2D, 1.7, and 8.4C. 1.2D and 8.4C certainly implicate and were admissions that he participated in dishonest conduct. The complaint arises out of the respondent's activities and affiliation with a group of insurance agents in Kansas that had developed a scheme, albeit what it ended up being an unsuccessful scheme, that was designed to allow these insurance agents to claim commissions on million-dollar life insurance policies. They marketed these policies to friends and neighbors in order to accomplish their efforts. It was necessary that they create a plan that allowed the insurance policies to be placed into trusts. They approached the respondent, and I say approached with some reservation because the respondent and these agents had a prior professional relationship prior to the time that the agents came to him and asked him if he could be involved with this. At the time, the respondent agreed to provide to and made the recommendations to the agents that they use template trusts, and he provided those template trusts to the agents to market with the insurance policies. The insurance agents went to friends and families indicating that they had a program that would allow the insured to be entitled to claim $10,000 in life insurance proceeds after a year without cost. The respondent knew that the insurance agent, Mr. Cox in particular, his client Joe Cox, the head of Epic, had secured premium financing in order to secure the higher valued policies. They did not make the insureds aware of that. They simply indicated, we have this program. After a year, you'll have the opportunity to have a life insurance policy worth at least $10,000 or cash value of $10,000. Sign here. The insureds signed applications for life insurance, million-dollar policies. They also signed trust documents designating the respondent as their trustee. The respondent signed the insurance applications as well as the trust documents. The insurance applications represented to the insurance companies that none of the premiums were being financed, that there was not an intent to finance the premiums. Those applications were relied on by the insurance companies as they issued these policies to the insureds and deposited them into trust. The respondent, in his stipulations of fact, admitted knowing that his client had in fact secured financing of these premiums, attesting to the fact that the applications represented that the premiums were not in fact being financed. In fact, he applied for one of these million-dollar life insurance policies on his own. He and his brother executed an application and secured life insurance through his agent client. In addition to the facts that were stipulated to, and in conjunction with the efforts of the respondent and his agents, he admitted during the hearing that he had not read the trusts that were submitted to him and that he was serving as trustee. He was aware that the premiums were being financed when the applications represented that they were not being financed. He admitted that he recommended to his client, Joe Cox, that it would be advisable to establish a bank account at the same location where Mr. Cox had secured financing under his law office's name, Advanced Legal Planning. He admitted that he granted Joe Cox's secretary or administrative assistant signatory authority on that bank account under his law enforcement, under his law office name, and that she, in fact, was funneling, for lack of a better word, orchestrating premium payments into his law office account and then paying on behalf of the trust these premiums to the insurance company. So he created a bank account to allow the agents to facilitate a movement from loan proceeds to his account and then from his account to the life insurance companies, and granted to his client's administrative assistant signatory authority on that account. During the hearing, he testified that he signed a promissory note on behalf of a trust offering the life insurance policy belonging to the trust as collateral for the premium, for the loans that had been obtained. And in quoting at Volume 2, page 115, he did that at his client's request, quote, in order to establish a paper trail because he, meaning Joe Cox, was being investigated. He admitted during his testimony that he signed documents as trustee in an effort to create a paper trail for his client who was the subject of an insurance department investigation. At the conclusion of the hearing, considering the facts that had been stipulated to, as well as the rules violation that had been stipulated to, the panel concluded that the evidence supported a finding of a 4.1 violation. They recommended a 2-year suspension and a reinstatement hearing. To this court, I would ask the court that you adopt that recommendation and find that the rules violations are supported by clear and convincing evidence, and certainly the sanction is appropriate.
Was there any criminal investigation? I mean, I know there was a regulatory kind of investigation by the insurance department, but was there anything other than that flow from this?
Not that I'm aware of.
Okay.
As of this time.
Right.
What was in it for Mr. Galloway?
That he suggested that he believed, should he be designated as trustee on any one of these trusts, and in fact there were 40 that were created in conjunction with this, the agent's efforts, that he would be able to then directly market other estate planning services to the grantors of the trust, that would establish a business relationship under the rule that would allow direct marketing of other estate planning.
So he didn't get any direct piece of the action, Mr. Cox's action? Not that I could certainly establish by clear and convincing evidence. It did not appear that, and that may have contributed to my recommendation in the case, it did not appear that he was reaping significant financial benefit from this. He did not at any time tell his client, you can't do this. This is not within insurance regulation, and it involves a deceptive practice. It did appear that the financial motivations were largely on the part of the agents and not Mr. Galloway.
Any further questions of counsel? Any further presentation?
Not at this time unless there are questions.
Thank you, counsel.
I'm John Ambrosio. I represent the respondent. Mr. Chief Justice, Your Honors, may it please the Court. I pride myself when I do disciplinary cases, and God knows I do a lot of them. I try not to waste your time. I try not to waste the disciplinary administrator's time, so I'll get right to it. My client understands what's in the panel report. He accepts all of the facts. Once again, he stood up and admitted all of his indiscretions. He understands how serious it is. He realized the conduct violates all of the model rules that the panel found. Originally, I recommended that my colleague recommended a 1-year suspension. I agree with her that the 2-year suspension that was handed down and suggested by the panel is correct and is needed, and I agree with the panel that there should be a reinstatement hearing. And the realization came later to me because I think as you read the panel's report and you go through the analysis that they did, it becomes obvious of what the facts are even more than we knew from the beginning. My client did reap a small benefit in that he was paid $250 to $500 for each trust, which in the scheme of things was almost nothing. He received a small fee for setting up these trusts and for giving advice to Mr. Cox. I am never one to denigrate other people involved in these cases. And before I make this remark, my client stands on the fact that he was wrong, it's his judgment, it's his law license, and he was wrong. But this scheme by Mr. Cox, I'm pretty slick, but I'm in the minor leagues compared to this scheme that he came up with. And thank God that he finally got caught by the insurance commissioner's office and was run out of the market, or this thing would still be going on. This was wrong, this was deadly, this was bad for the people. My client, whether unwittingly, unknowingly, or whatever mark you want to use, was taken in by this. And
well, Mr. Ambrosio, I'm sorry. If your client couldn't recognize the wrongfulness of this scheme up front, then I question whether he's competent to be an attorney and represent the citizens of Kansas. This was obviously wrong.
It's obvious to me, but I always look across the desk when I'm representing a client and see the enemy. I understand that. I'm not sure my client really analyzed it and realized it. That doesn't mean he's incompetent. That means that he made some mistakes. That means that he didn't look carefully enough. That means, Your Honor, that he did not do the due diligence that maybe you or I would have done. That means he was taken in by this person. I don't think that makes him incompetent. I think it makes him a dupe. And I think now he realizes, and that's what he's to learn by the 2-year suspension and why we agree with the panel's 2-year suspension. You learn when you're punished. You learn when there are consequences. And he has learned from this process. He has learned by being here today. He will learn in those 2 years. And let me tell you what he's doing now. He's gone back to KU. He's going to try to get a graduate degree in elder law, certificate, I guess they call it. He took 5 hours this semester. He's going to take 7 hours next semester. Is doing it part-time because he has a large family, and he hopes to practice law again. And frankly, the 2-year suspension, when you have to have an admittance hearing, really takes about 3 years. By the time you do the process, pay your fee, get the application in, the disciplinary administrator's office does the investigation, you have a hearing. As you know, it's usually almost 3 years with a 2-year suspension before you're back. And I think this is a learning experience for him. And I think he'll continue to take CLE. I think he'll continue to do everything he needs to so that this won't happen again. Now, without further ado, since my client did own his own behavior, since my client does accept what the panel needed out, my client would like to address you.
Before he steps up, counsel, I'd like to go back to a comment you made. If he is intending on practicing elder law, those are particularly vulnerable clients who depend almost entirely upon the abilities and judgment of their lawyers. So when I hear the disciplinary administrator indicate that he signed documents in this, what everybody calls a scheme, without reading them, could you or your client address that?
And I'm hoping that my client will be the one to address it. My gut feeling, my colleague is absolutely correct. That's what happened. That's what the testimony was. That's what the panel found out, and he was wrong to do that. And I understand that this is a vulnerable group when you represent elderly people, and it's going to get worse as we go on. I think he understands what he did. I think he understands and he owns that behavior. And I think owning your behavior and not making yourself a victim is the first step in righting the wrongs you created. It's the first step where I'm a fallen away Catholic, albeit still probably a Catholic. Confession was really good for the soul, and then you would try not to commit those same sins again. I think confession has been good for the soul. And the realization from talking with me, the realization from talking with my colleagues in the Disciplinary Administrator's Office, from hearing what the panel has to say, I think the lights are on, and he understands the situation now. And I think the 2 years will give him more time to think about his situation and to understand that the judgments he made were wrong, that he hurt people, and I don't think you'll ever see him back here again. I hope that answers your question.
It does. Thank you.
Mr. Galloway.
Mr. Chief Justice, Your Honors, my name is Mark Galloway. I'm the respondent. Before I go into the comments that I had thought to make, I wanted to make a clarification to what my counsel had said. He said that I received the $250 to $500 for setting up each of the trusts, which was not technically accurate. In my prior work with these insurance agents, they had paid me fees to create trusts. And when I heard from one insurance provider that they would think of that as rebating since they were paying me to do the trust work when the client should, I told them that I could no longer do that. And so my fees were to be the trustee. When I told them that I couldn't create the trusts, Mr. Cox said, well, these policies should be owned outside of the estate where they're protected, and maybe I'll just use a trust from a form book, or I'll get one offline. And concerned that those wouldn't suffice, understanding estate planning, I agreed to go ahead and create the forms that their office would use instead of them getting some unknown form online or from a form book in a bank. But my fees were not for that. I did not read the trusts after they were signed, but I did draft them and knew what was in them. I have agonized over what to present to you. In the hearing, there were lots of letters and there was testimony discussing how I had given a lot of free help to people and been an honest person, and even Miss Baird talked about a lot, the free help that I'd given. Maybe I was doing too much. Maybe I needed time off to realize what it was to be an attorney. At the time, and still, my wife is recovering. It's been over 5 years now that she's had medical problems. I've been practicing from my home, minimally, maybe 20 hours a month at times, while I take care of the kids and help her. But and I think Miss Baird's right. In a lot of ways, I have forgotten what it is to be an attorney, and I did not approach this case with the care that I should. I received a call from Mr. Cox, and he said, let me back up and set a stage. We had been involved in doing what's called premium financed insurance, which looks too good to be true on the face, where people were able to get insurance for no cost, and it was legal. And in fact, some of them later on would sell their policies and make money on the arbitrage. after the life tables changed, that industry went belly up. There was no ability to get the financing anymore. So when Mr. Cox approached me with this opportunity, he said, hey, I've found another way to be able to help people do this. And I said, okay. And as Ms. Baird stated, I got a policy myself. And I talked to my brother about getting a policy. And he got one. And I thought all was well. The fact that I signed the documents stating that there was no financing, where in fact I knew that there was, is difficult to reconcile with the testimony and the letters saying that I'm an honest person. I would only ask the court look at the panel, the testimony in the panel that states that at the time I was under the impression from my work in premium financed insurance and other insurance companies that these small-term bridge loans, or short-term rather, were not qualified as financing on those documents, and I should answer no, which is what had been done in prior times. I did not confirm that with Mutual of Omaha, which was the only insurance carrier that I dealt with on this, as I should have. I didn't disclose. I just took it as a matter of course and trusted Mr. Cox as I had in the past. I did not act with the care that the dignity of the office of an attorney demands. And I am sorry. I got into law because I wanted to help people, not because I wanted to make a whole lot of money, which you might be able to see by the small amount that I required. It was supposed to be a simple thing. To be the trustee for these wouldn't require much work. That simple thing, combined with my lack of care, lands me in front of you today. I want to help people. In the closing arguments before the panel, my counsel told the panel what I'll tell you today, which is, I am an honest man. I don't know how I got to the point where I was so careless. If I have the opportunity to practice law again, I will still be honest. I'll be the same man you see before you, but I will practice much more care. And I would ask the court's forgiveness. One of the things that hurt when I read it in the report from the panel was that although I had taken care to make sure that none of my clients could get hurt if things went sideways, I mean, that's what estate planning does. You make careful plans, and I protected my clients. They said that I had done damage to their practice of law, which I believe is correct. I believe if I were in your seat, I would have to suspend me. And I believe it's warranted. And I believe that also that I can take this time to make myself a better attorney, so that if I'm allowed to return to the practice of the law, I will be able to represent people with the care that they're due. Thank you.
Let's talk about that, and I think my question's probably better posed to counsel, at least to shepherd the answer. If we focus on paragraph 58 of the hearing panel, which is the one that says, upon the application for reinstatement, we need to assure ourselves that there's been additional training in ethics and unauthorized practice of law and better business judgment. How are we going to do that, I guess, is the question. We're taking a course of study in elder law at KU. Do we think that gets it done? If so, how? Are there other things that we're going to do? I mean, I'm still wrestling with what the reentry plan needs to be in order to protect the public upon reentry, if that's the way we go.
Obviously, I agree now that we need a hearing. I'm cognizant of what's in paragraph 58. I think he's going to pick up some knowledge during the course of graduate study in the next 2 or 3 years about what it is to be a lawyer and how we're to do it in appropriate fashion. I think in addition, he's got to continue in his CLE and to take additional ethics hours, because I think the more ethics hours you take, the more you learn. I mean, I do this work all the time, and every time I hear a presentation or give a presentation, I learn something. Every time I go to a grievance meeting every month, I go back totally neurotic and my OCD kicks in. I think that happens when people go to CLEs. I think they pick up the knowledge, and I think as long as he continues with his CLEs and does additional ethics hours with those CLEs, at the end of that 2 or 3 years, if he's allowed back by the panel, and if this court follows the panel report, I think he'll be okay. I trust that answers your question.
Is the elder law being run through the law school or through some other part of KU?
It is through the law school, Your Honor.
Any further questions? Any further presentation?
No, Your Honor.
Thank you. You reserve 3 minutes for rebuttal.
Before you get started, can I keep my same thread of thought here? And do you agree, what's the reentry plan look like if that's the way we go with this? Because paragraph 58 is a lot more specific in educational elements and business practice than what we normally see. I mean, normally that reentry, we're looking at rehabilitation from alcoholism or rehabilitation from those standpoints, and this is more of a business common sense kind of provision, the way I'm looking at it. So how do you view that paragraph 58?
That may have come from the argument that I made in requesting a reinstatement hearing before the hearing panel. There's what I perceived at the time, and in retrospect, looking at the evidence and the hearing, a complete lack of lawyering by the respondent. Complete lack of lawyering. No counsel, no. Here are the issues that are presented in what you want to do. You can't do this because if you choose to take this course of action, I won't be able to participate in it. There was an absence of lawyering. There was a demonstrated, and I think I would suggest we've seen it here today, I want to help. I want to do what you want me to do. I want to help you. Here's how I can help you do this. I'll give you these template trusts. I want to help you. There was testimony at the hearing that the respondent spent hours on the internet offering legal advice over the internet. Pro bono legal advice. That he traveled to Idaho to meet a client or a colleague that he had met at a conference to help him set up or work on his estate planning practice at no cost. He just traveled to help him, and he spent days there working with this person and developing a practice. There were letters of reference offered by a charitable organization in Florida that the respondent had connected with over the internet and offered pro bono work
to these individuals. I agree. And we heard very, very many times that this person, this, by all appearances, very good person, wants to help people. Very little evidence of his practicing law or engaging in the profession that he was trained to engage in, and then offer assistance to clients by virtue of that advice, of that education.
But the question then becomes, how do we assure ourselves that he has come to the realization of what it takes to be an attorney or what it takes to practice law? I think that's Justice Biles' question is how can we be assured that he won't fall back into the same mode?
And only through a reinstatement hearing and through a demonstration that this person has recognized that while we all may be motivated to help people, that as a professional, sometimes our obligations are, no, always our obligations are, to give the client counsel in the context of what's required by the law. Sometimes helping someone by offering these template trusts isn't really helping them. And I had hoped that at a reinstatement hearing, we might have an opportunity to see an assessment by an individual, perhaps better trained to explain some of the behaviors that were demonstrated in this hearing. And I would expect that we might be looking for that at a reinstatement hearing. I don't profess to be have any expertise in how the mind works, but what was demonstrated at the hearing and in this conduct simply didn't make sense. The big picture.
Let me ask you this, because this may get to it. Are you trying to suggest that the reinstatement hearing, as one component of it, ought to have some sort of psychological evaluation? Or is this the kind of thing where after the 2-year suspension, what we really need to do is set up an appropriate probation plan for 1 or more years where the individual's practice can be observed and monitored to protect the public? I mean, that's why I'm struggling a little bit with the reinstatement hearing, because you can come in and say, look, I had these extra courses at KU. Well, I'm not really sure either of our law schools teach anybody about practical business sense. So, I mean, are we really talking about just being able to monitor and protect the practice of law for a while and satisfy ourselves that way? Or is there something else going on that needs to be evaluated?
I would suggest that I would want to rule out that there was not something else going on. I'm not prepared to say that there is, but I certainly would ask. So the short answer to your initial question is both. I would be asking for an evaluation as well as monitoring. And it may be that it's demonstrated that there is no issue that warrants any kind of an evaluation may say there's no issue here. But I would certainly suggest that it's appropriate to rule that out. And again, that's based upon the objective evidence that was demonstrated through that was provided at the hearing concerning the practice of law via the internet, and outside of the community at a time when clearly there were personal responsibilities that required that service to be provided to earn a living. So, in any event, if there are no questions, I don't know that I have anything to add.
Any further questions of council? Thank you, council. Thank you all for your comments this morning. Court will take this matter under advisement